Hello viewers, good afternoon, Assalamu alaikum, and I hope everybody is watching us. So we have our panel set today. I'll introduce you to my panel. On my right side I have our partner Nazir Ahmed Naji Saab, who will be able to give us new updates on immigration, and probably he would like to talk about any particular topic, and whatever questions you have in relation to immigration, we would be happy to answer them here. And I just remind you, you can also send us an email on info@m-rsolicitors.co.uk. Then we have another colleague, Salman Nabi, who's expert in litigation, wills and probate matter. Today he will be giving us some information on probate matters. And if you have any questions in relation to litigation generally, or particularly to probate matter, please do ask us. On my left side, we have another partner, solicitor in property matters, Sonia Beg. And again, if you have any property matters, she will be giving some information, useful information on property matters as well. But if you have any particular question, please do ask us. Finally, we have our guest, Imran Qazi Saab. For last 2 weeks, he has been giving us time. Thank you very much, Qazi Imran Saab. So he will be giving us information in asylum related matters. So if you have any particular question about the procedure, how these things are happening, especially in these days, how Home Office is reacting about the screening interview, full interview, so you can always ask us questions. So the email is info@m-rsolicitors.co.uk. So to start with, I think we would like to start from the immigration side, and I would open up the discussion in relation to immigration. There have been updates in immigration which we have been informing you for, and as we all know, that still the deadline which the Home Office had extended from 31st May to 31st July remains at 31st July, and this was the deadline for those visitors who have come to this country on visit visa with a single entry of 6 months, or on a multiple visa, but again limited entry for 6 months, and the date of entry was after 24th of January, and their visa was going to expire, or is going to expire for 31st of July anytime, and they cannot go back because of this pandemic situation. Their visa automatically will be extended, their entry automatically will be extended until 31st of July, but they do have to send an email to Home Office. If they haven't done so, they can still do that. The other important information in relation to this deadline is all these visitors who are in the country and they intended to go back and long-term application, whether that was student leave or parent settlement application or work permit application, innovator startup visa applications, they can do so whilst they are in country. It's contradictory to the rules though, but because it's Home Office discretion, they have given this flexibility, so you can do so before 31st of July 2020. Again, tier 2, the work permits, and tier 4, the students, all the sponsors have been notified by the Home Office that if your students are not coming, you don't have to report us. If your employees are taking days off because of this pandemic situation, you don't have to report us. They can carry on online courses if they're doing so, but if you have any particular situation, you can contact us or you can ask us questions here, and we will be able to reply to those. So opening up the discussion here with Naji Saab. Naji Saab, we were discussing about this work permit category, and the Home Office has announced some changes from coming January 2021, where they are going to take out the requirement of advertisement, and the salary threshold has been brought down, but that is from obviously January 2021. But also the sponsors have started asking questions. Those sponsors who have not taken the license from the Home Office, they want to do so. So because the threshold has been reduced, so they want to get employees from abroad. So if you can shed some light on how they go about it, how they can apply to the Home Office to get sponsorship license.
Yes. Basically, the Home Office has different types of licenses. We used to call them work permit, but now they call it Tier 2 and Tier 5. In Tier 2, they have further categories of these licenses as well. And the Home Office is encouraging everyone, especially the companies and the charitable organizations or any other organization for that matter, to apply as soon as possible. So that when next year starts, their licenses are in place and they should be then able to employ those people. So the different kinds of sponsored licenses which the Home Office currently offers and which are more applicable to our situation is Tier 2 General and Tier 2 Intra-Company Transfers and Tier 2 Minister of Religion, and then Tier 5 the temporary workers categories that covers religious workers, sports person, creative artists, and then charity workers, and then there are people who come on government authorized exchange programs, and some people who come under international agreements, and then the seasonal workers, they come under tier 5. Basically any company who has genuine business in the UK, they can apply for these licenses. And the government basically wants to know that you are a genuine employer and you have a lawful presence in the UK. For that they require certain documents when you apply. You need to have certain documents in order to make your application, which is mainly online. But obviously once you make the application, you pay their fees and provide them the relevant information. Then you have to provide them the documents in order to support your license applications. The Home Office used to require the original documents initially, and then they relaxed their policy and started asking for certified copies of the documents. So this was quite a relaxation. But due to current COVID situation, they have further relaxed their rules, and now they are asking that you can even email us the PDF copies of the scanned documents. That is quite development from the Home Office. So that was in terms of eligibility. They want to know that you are a genuine employer and you have a lawful presence in the UK. And once you have this, then they consider whether you are a suitable employer. And for that, they want to know that as an employer, you have system in place, especially your PAYE system, your HR system, so that whenever if they want to make an inquiry or if they want to make a visit to your premises, then all these things should be in place just in case if they want to know about this. And also the persons, there are two key persons which are required from your organization, and those key persons, they shouldn't have any criminal conviction, otherwise that might affect your sponsorship license. So basically the government will put you in trust, the key persons from your organizations. So they will be then reliable, they should be the reliable persons because they will be responsible, because they will have the sign-in details and all the contact with the Home Office. So just in case anything happens or there is a change of circumstance in terms of your employee, and then you need to, within 5 working days normally, you need to update the Home Office, otherwise your sponsorship license is under, they can be cancelled or revoked. Normally, the documents which are required to support your license applications is basically they are readily available documents. Basically, the Home Office normally requires, if you are a company, they want to know your employer liability insurance for up to £5 million. They want to know your certificate of VAT registration, and they want to get information in terms of your HMRC registration and your recent bank statement confirming that you are trading. And if you have recently started trading, then a letter from your bank should be sufficient. And then they will also require a proof of ownership of your business. If you're a company, obviously you will have a certificate from the company's house. But if you're not a company, then probably you might have a lease in place, and that should be sufficient. So these are the documents which are required. So once you provide scanned copies of these documents, then and pay the Home Office their fees, and then they should be able to decide your application. They normally take between 4 to 6 weeks in order to decide such applications. Yeah, that's almost it. Basically, you need an authorizing officer which will be responsible to manage the Tier 2 license, and then there will be a key contact person who will be a person, if you need to contact Home Office, then that person will have that responsibility. Yeah, and then once you are given a license, then the Home Office will let you know that how many people you are able to sponsor, and then you have those sponsorship duties. You have to update the Home Office in terms of any change of circumstances. If it happens, then it has to be within 10 working days. And then the Home Office can ask you for an interview once you make an application, or they can have a compliance visit at any time. And once you are granted license, then they will let you know that how many people you are able to employ. That's about it, unless you have any further questions.
Nice, sir. I have a question.
Yeah.
So many friends ask, is there any specific field they specify for Tier 2, or any company who has a certain level of income and the threshold, and they fulfill the UK government requirement, they can sponsor the employees?
Like they said, they haven't mentioned a particular threshold. The Home Office wants to know that you are a genuine employer. By that, they mean that you must be trading, you must be registered in the UK. So they haven't mentioned a threshold, so that they want to encourage all the people, all the companies. If they would have mentioned, for example, you should have maybe 1 million or 2 million turnover, then a lot of small companies would be discouraged by this.
Excellent.
So that's why they want all the companies to encourage all the companies so that they can apply for their licenses. The only thing they require is that you must be a genuine business. You must have systems in place whereby you have this HR department, and you are able to comply with the Home Office requirements, because they are very strict on that.
Yes. Thank you.
Okay, thank you, Naisab. That was a very detailed explanation. I would ask and request all the participants here, when you are speaking, speak loudly, because there is suggestion that probably they can't hear us properly. So next session we'll try to have mic as well to all viewers. So if you could not hear it properly, but I hope my voice is loud enough, and the next speaker, whoever it will be, will have loud voice as well. So we also take some questions in between, and there's a question about EEA, Extended Family Member, and the basic question is how to prove dependency. financial dependency. You see, the main requirement of this application, if we are talking about Regulation 8 under EEA regulations, they want to know before coming to this country, in your country of origin, were you financially dependent upon your sponsor or were you part of his or her household? So yes, this is a common refusal ground when they say, okay, when you came here as a student, for an example, in your application form you did not mention that this sponsor was sponsoring you, or you have not provided sufficient documentary evidence to confirm your previous dependency. There are different ways of proving that. But first of all, I would like to make this point, that whenever we are making application, sometimes we do submit documents as well with it, but we do not try to make any relevancy between the documents and our previous immigration history. For an example, in this particular situation, where a student has come here and then he or she is making this application. So when you made an application for student visa, whenever it was, in your country of origin, in the application form there was no specific question who is sponsoring you. You did not have to give the details of your sponsor. So either you must have given your own bank statement or you must have given one of your parents' bank statement. So when you're making this EA application, you have to leave it like that. You have to justify that I did not have to mention in my application form at the time of student visa, or how I can prove that this money actually which was in my account came from my sponsor. So one way of doing, as you mentioned in your question, money transfer receipts. See, whatever you give, you have to corroborate that with another piece of evidence or a credible source, or another credible witness statement or something. So if you are giving, say, 24 or whatever money transfer receipts, so when someone is sending money from this country to your country of origin, and I take that, say for an example, Pakistan, and you are providing those money receipts from Pakistan, but the person who has sent you money from this country, he will have some proof as well. If it was from the money exchange company, you will have receipt from them. If he has sent you money from his bank account, the bank statements are there. If he has sent you money through a private personal friend, then the personal friend's statement as well as his passport copy to confirm that he did travel in those dates. So you have to corroborate your evidence, whatever you are trying to convince the Home Office for. So this is a main refusal point. Home Office uses that previous dependency and plus the current dependency. So if you have a particular question, please send us email on info@m-rsolicitors.co.uk and we will try to give you a specific response to your query. But that is the general criteria I have explained. I'll just take another question. Okay, if you are on universal credit, does it affect your spouse visa application? But what about if someone is applying just because of COVID-19? Okay, because of COVID-19, the threshold of 18,600 for spouse visas, initial application or extension, the Home Office has not brought it down. This is a very general question we have been asked frequently. So the answer is they have not done so. But what they have said is they will look every case on their own facts. So it will vary case to case. So if there is a genuine situation that for 7, 8 months, 9 months, or even before you were in receipt of a regular income, and if you had continued with that income in normal circumstances, you would have crossed the threshold of 18,600. But because of this pandemic situation, you are furloughed and your salary has gone back to 80% and the difference is only 20%. I'm sure Home Office is going to look into that and they either will hold your application or they grant you temporary extension, and once your income threshold is okay, you can make an application again without paying extra fee. This is the kind of flexibility they are saying, but they have not reduced the income threshold. So if you are claiming any kind of benefit after receiving, there are circumstances where you are earning 18,600, but because of the size of your family, you still are eligible to some kinds of benefits. You can claim them. It will not affect the application as long as 18,600 threshold has been met. But because of the situation, it's gone down. You need to explain the Home Office. Don't delay. Just send your application with this explanation and whatever evidence you have, send them and request them to either grant you visa or put you on hold or grant you a temporary visa at least. So once the situation is better, you can send the application again. And I'm sure on one hand, they are giving you so much flexibility that all those visitors whose visas have been expired, they can still stay here legally until 31st of July. All those visitors who wants to switch the category, they can switch the category. So I'm sure Home Office will use their discretion here as well. So don't keep your application, just send them off. Again, if there's a particular question, then consult your legal advisor. What I'm saying, it is a general advice. Another question we have is in relation to EU citizen taking child benefit, which is about 20-21 pounds. Does this affect when you are due? If you are EU citizen and your child also has European passport, yes, you are eligible to take benefit, child benefit. But if the child is not UK resident, European resident, then yes, the child benefit is not allowed to you. So if you are taking that benefit, it will affect your application in circumstances. If you are looking for a job and you are EU national, they allow you up to 6 months. But getting child benefit, housing benefit, all sorts of benefits, it may go against your PR application. So please do consult your solicitors or send us an email with your particular circumstances, and we will be able to advise you accordingly. I also welcome all those friends and professional friends who are watching this session. And as I always say, all my professional friends, all the barristers, consuls, I would like you to come and join us as well and give important information to the clients via this live session. So I will move on to, before I take a few more questions, I'll move on to Salman Nabi, who have some information for in probate matters. So Salman, if you can shed some light on that, please.
So thank you. Traditionally, probate wills, it hasn't been a very popular subject in people from our community, and understandably so, because to make wills or probate, it presupposes that you have a lot of assets. It's more recently, it's become more relevant because more people have assets to dispose of at the time of death, and they have large families here, and so wills and probate it shouldn't be limited to any particular type of people. It shouldn't be limited to any particular community. It's something we should all look into now, simply because it simplifies the disposal of assets after death, whether you have a big family or not. It's something we should all consider consulting our lawyers about, because there are lots of practitioners who specialize in wills and probate matters, who will be able to draft wills and execute wills on your behalf. It's, as I said, it is simply a way to simplify how your assets will be distributed and disposed of after your death. And it doesn't necessarily have to be done just before you think you're old or in anticipation of death. We should all try and do it well beforehand. And there's always scope to change it and make amendments or vary the will as and when needed. But we should always consider, drafting and executing a will that will help give transparency and predictability to what happens to our assets. Just to explain, a will is simply a document where you state how you want your assets to be distributed after you die. There is obviously certain formalities that we have to comply with to make sure that the will is legal and enforceable. For example, you have to have two witnesses when you sign the document, and the two witnesses also have to sign in your presence, and obviously you have to intend to make the will. So there are certain formalities and there are some certain requirements that the court will look into to decide whether a document qualifies as a legal and valid will or not. Your legal advisor or your solicitor will of course if you engage one to execute a will, will of course make sure all of that is complied with. But you can also do a will yourself. You can download will packages online for free. Some websites provide that service. But it is always better to consult a solicitor, just because prescribed wills and package wills that you get online may not be completely relevant to you, may not be appropriate for your situation and for your needs. So it's always better to consult a solicitor and instruct a solicitor to draft a will for you. But once the will can relate to a particular asset you have. It can relate to all your assets. It can even relate to an asset you intend to have in the future. How it will be dealt with will be entirely dependent on how you execute the will, how you word the will. So mainly people use a will to decide how their house will be disposed of after they die, or shares they have in companies, or cash in bank accounts, or bonds, or even cars and personal items of value, for example, jewelry or an expensive watch or anything. Will can relate to any asset you have. And of course, people who don't have a will, their estate or all their properties after their death is disposed of by the rules of intestacy. That's what lawyers call the rules that relate to how your assets are disposed of if you don't have a will. Now, if you don't have a will, the wills of intestacy will dictate that part of it will go to a surviving spouse, for example, if you have a wife or a husband or a civil partner. And so part of it will go to the children, and if there are no children, and if there are no surviving spouse, it may go to a parent, a surviving parent, and if there are so on and so forth, it may even go to siblings of full blood and then to half blood. So the main reason why we advise making wills is because you may not want the rules of intestacy to decide how your assets will be disposed of. You may want to gift certain assets to a particular friend. You may want to give away certain assets to a daughter that you have from a previous marriage, or even to a close relative who's not a son, who's not your child, who's not your parents, who's not your brother, but he's a very close relative who you feel that you must give something after you die. The rules of intestacy leave those people in an unpredictable situation where they don't know if they will get anything. So it's always better to, if you want to, it's always better to have that clarity set in place beforehand in the form of a will, and that will decide where your assets go. It can go to anyone you want in the will. And of course, the will does not necessarily have to relate to properties in the UK. You can have wills that involve properties you may have abroad, wherever you have assets in, for example, in Europe or even in Pakistan, India or Bangladesh, wherever it is. And the laws of this country also recognize wills you execute in other countries. For example, if you make a will when you are in India or Pakistan or Bangladesh, that will is also recognized in the UK, provided it complies with the requirements of a valid will in this country. So don't think that your will should only be focused on your properties in the UK. It doesn't have to. It can include any properties or assets you have anywhere in the world. The will should have directions relating to all your assets and how you want to dispose of it. So once the will is done, I'll just briefly describe what the process is once a person dies with a will. So once the will is done, you can state in the will who you want to be responsible to dispose of all the assets, what we call the executor. You can name the executor in the will, provided that person is also willing and able to take on that responsibility. So once that happens, your solicitors will make an application to the probate office for what we call the grant of probate. So that will basically give permission and authority to the executor to deal with all the assets in accordance to the will. If there are no executors, or if you don't want to name anyone in particular as the executor in your will, then the court will appoint an administrator. It can be a close relative, it can be anyone not related to you, it can be anyone who's willing. The primary responsibility of the executor or the administrator is to make sure they deal with all your assets, be it a property, be it bank accounts, be it shares in a company. They will have to make sure that it's dealt with in accordance with your wishes in the will. And for that reason, it is essential that your will is clear and your will does not contradict anything else, which is again why sometimes it's best to instruct a solicitor to help you make the will. Of course, once the grant of probate is done, then the authority is given to the executor or the administrator to deal with the assets. But prior to that, you also have to consider the issue of inheritance tax, because in this country, if your assets go over a certain amount, then you will have to, your estate, the properties you leave behind will be liable for a tax to be paid to government. And of course, the threshold varies according to who you leave the properties to. For example, if you leave it to your surviving spouse, then there's the threshold is very large. I mean, there's very little inheritance tax applicable. If you leave it to your children, then the threshold goes up by almost twice, not close to being twice. So it's a lot more depending on who you leave the properties to. But inheritance tax is again a very big issue, because we all want to make sure that you don't pay any more tax than you are legally required to, which is why again it's essential that you instruct and you consult your lawyers as soon as someone in your family dies, to make sure that all the assets are dealt with in accordance with a will, if any, and if there is no will, it is done according to the rules of intestacy, to make sure that every tax and charges on the property are dealt with efficiently and in a way that best suits everyone.
Thank you very much. It was very much detailed but relevant, useful information in relation to wills and probate. So please do consider this, as Salman rightly said, that people from our Asian community, they don't pay much attention to this, and probably they don't know that the will written in this country is valid in your own country as well, or will written there can be valid in UK as well. So any further information, please do send us an email on info@m-rsolicitors.co.uk. I have a few more questions. I'll try to answer those. Thank you very much, Faisal, for asking this. Can student change category, and what categories he can change? Yes, definitely. Student can change category from student to work permit, startup visa, innovator visa. If he was not married before he gets married here, he can switch to spouse visa as well. So it really depends what you want to do. After summer 21, the students who are actually coming, say, practically speaking, from January 2020 onwards, and the shortest course they are doing is, for example, 1.5 years master degree, and they will be finishing in summer 2021, June onwards, they will be able to apply for 2 years work permit. We don't know the exact category, but we assume it's going to be something like PSW visa, which we used to have before. So students will be again considering UK as their destinations like they used to until PSW was there and highly skilled programs were there. So Home Office has also announced that they will be considering work permits, highly skilled work permits as well, where probably you will not require a sponsor. So highly skilled migrant scheme kind of category they may introduce beginning of next year or so, and work permit flexibility is coming up again. For students, there is startup visa and innovator visas already. They have implemented, so there are many categories you can count on. The other question is EA settlement related. You said that you already got settlement visa, which means indefinite leave to remain under EEA. Now you are not with your partner, and it was just a partner, not spouse. You were never married before. and if there is a separation now, do you have to inform the Home Office? You do not have to inform the Home Office because you are out of immigration control once you got indefinite leave to remain in that respect. Yes, when you are making an application for nationality, it will be relevant whether you are married or not, but in terms of indefinite, after getting indefinite settlement visa, you don't have to. Now the next part of your question probably is that now you want to sponsor your new partner or spouse from Pakistan. Yes, you can do so, and you have to meet the threshold, income threshold of 18,600. Your spouse has to meet the English language test requirement, and all other basic requirements you need to meet. So yes, you can sponsor your new partner or spouse without informing Home Office in advance. There's another question that if someone, a European person still can sponsor cousin, which is the extended family member from abroad, and the deadline for it. Okay, if the EU sponsor is already in the UK and he has obtained this pre-settled or settled visa, then yes, he can sponsor, and the deadline for him would be 30th June 2021. But all those people who have not come into the country yet, the deadline for them to come and apply for settled or pre-settled visa is 31st of December 2020, because after that date practically Brexit is going to happen unless something again drastically changed and the government comes up with some other legislation, but at the moment that's how it is. We move forward, and we have Sonia Beg with us, who's expert in property matters. So if you have again questions, please keep sending us your questions in relation to whether it is property, it is litigation, it is asylum, it is immigration, or any general question you have in your mind. This is the time for you to ask us, and we are here to try to explain as per our ability. So welcome Sonia again, and thank you very much. We were discussing that property matters, and at the moment conveyancing obviously is on low due to the situation, but what you are thinking, how the market is responding now, and what further information you have for us in relation to this.
Thank you. Thanks everyone for joining in today. So just a brief continuation on that. So the market is picking up in the last few weeks, so people are looking to buy and sell now again, so it has picked up. And then just a bit of clarity, because there is some confusion for people on how they own their land. So you can own it as the freehold or leasehold, and usually there's a lot of confusion between what they actually mean. So just as a simple explanation, with freehold, that's where you actually own the house and the land it sits on. As opposed with leasehold, that's where you actually have the right to occupy the property for a specified amount of time. So sometimes that can be a bit confusing for some people to understand. So I'll just briefly walk you through it. So for example, with leases, the most important thing to bear in mind is the term of the lease. So typically you can see leases between 90 to 120 years, sometimes even up to 999 years. And the longer the lease, the better, so the higher the value. So a lot of the times, if you only have a few years remaining on your lease, many lenders will not find that favorable and may refuse to offer you a loan on that. So look, one thing to consider is possibly in the future is to consider lease extension, and just bear in mind they can cost a bit. But if you do have any questions, obviously speak to your solicitor and they can advise you on that. The other things to also keep in mind with leasehold properties is once you've done your completion, it doesn't just stop there. As opposed with freehold, you own your house, you're happy, you sat there, no one's going to come knocking on your door asking you for further payments, as opposed with leasehold. So things to bear in mind is there's extra charges when it comes to leasehold properties. So you have to pay, for example, ground rent, and that will be detailed in your lease. So when you come to negotiate and you found the property, you'll have your contract, which will have the contractual terms you've agreed with the seller or the buyer. So it'll have the rights and obligations for each party. Then in addition to that, you have the lease, and it's the lease document itself that'll give you the rights and obligations that each party has to bear. So for example, it'll specify if you're the buyer, what you have to do and what you can't do. For example, pay your rent. For example, don't sit there knocking down the walls, just a general example. And then it's very detailed. They can look scary, but just go through it, and if obviously you have questions, you can ask your solicitor. So one of the charges to look out for is the ground rent, and definitely have a look to see how often it gets reviewed. Yeah. These can be quite often and can be quite scary for some people. And then another thing is you'll find, which a lot of leaseholders sometimes have an issue understanding, is service charges. they can be very high, but bearing in mind they cover a few different things. So for example, in these service charges, they'll include things in there like each leaseholder will have a certain proportion or fixed percentage that they have to pay. And the services is to maintain the building, so the common parts, for example, staircases, or the hallways, or repairing of the roof, for example. Those, obviously there's many things that they can include, but those are like the major stuff to find in there. Another thing that can be included, and you will have to contribute to, is the building insurance. So you're not paying the whole insurance for the whole building, but just the portion that you're actually in occupation of. And then, so if you are buying a lease, and someone's already living at the property, just make sure that the services have already been paid up to date. So when you do come to occupy, you're not paying the services from the tenant that was before you. Just a little something to bear in mind. And then other costs that sometimes can creep up are administration costs. So these can be things like one-off payments. So for example, if you've been living there and now you've decided to sell, you may need to ask them for consent. Or if you decide that you need to change, you want to run a business from your property, you will need to ask for consent. And a lot of times the landowner, landlord, or the freeholder, they will charge a fee for their consent. And then if so, they'll agree, they'll give you their license if you need to do anything, but again, you may have to pay their costs. Or for example, if you do want to sell to another person, you'll have to send them notice. Your solicitor will deal with all this, but just bear in mind, this will cost you more money. So for example, other things to bear in mind is other costs that can be, if you ask them to complete any forms, landlord costs, freeholder costs, all these land property information packets, they will charge you for them as well. And then if you do have a mortgage, they need to be aware of who your lender is, and you need to serve notice on them as well. So these are just some of the things to bear in mind on the extra costs. And then other things to bear in mind is sometimes there are some companies where they have a management company for the building, so you can be a shareholder, and you can, with the other flat owners, you can manage the building together. And then sometimes you can have the right to buy the freehold. Not very common, but it can be available to you. If that is something you're interested in, please speak to your solicitors as well. And then sometimes there's other ways of holding the ownership, which is common hold, but funny enough, it's not actually that common in this country. It's just a few properties that are. But those are just the different ways you can hold the property. So freehold, leasehold, and common hold. And today was just a little brief introduction on leasehold, just to give you a better understanding. And if you do have any questions, please do let us know. We're happy to help. Thank you.
Thank you, Sonia. There was a very quick information and very relevant, and there was a relevant question that do we deal with commercial leases? The answer is yes, we do deal with commercial leases, residential leases, all type of conveyancing matters and leases we do deal with. We do take almost all kinds of cases. At the moment we are not dealing with personal injury, but hopefully within a month or so we will be starting a personal injury department as well, and we will have here a personal injury expert with us as well, and we'll take your questions on that as well. So anything to do with law, we are trying to help you there. Our mission always has been client satisfaction, and our vision is that we want to be law firm of future. So we want to give you all the information which you require, whether it is to do with immigration or conveyancing or litigation or criminal or personal injury or any corporate matter. We would like to give you information whilst you are sitting in your comfort of your own home. A few more questions and then we move on to Imran Sahab, your asylum category. So the general question is that what is the time frame for application these days from the Home Office? So Najib, is there any change, or it's still the up to 6 months standard criteria they have?
It's still the standard criteria, but obviously with Home Office you never know. But that's what they are saying, that they can take up to 6 months in deciding such applications. But because of COVID-19, obviously they are closed for the time being. So they're taking extra time nowadays. So that's what it. From Sonia's, I was picking up one point. Lot of people they don't know what freehold is, and they don't know what leasehold is. Sometimes they are stuck in a leasehold property, and they want to, for example, buy the freehold of the leasehold. So if you can expand on that, So that there are a lot of people who are in this situation because once they are buying a property or a business, they think they are buying it so it is a freehold. They don't know the concept of freehold and leasehold. So once they buy the leasehold, then they realize, oh, we are stuck. We have bought it for, say for example, 10 years or 1,000 years or whatever the lease term is. So if you can expand on that, how they can do it, and also people who are coming to the end of their lease, if they want to extend that, if you can shed some light on that.
Yeah, sure. So with leaseholders who are trying to buy the freehold, that's called enfranchisement, and can be quite complicated and lengthy, and not everyone will have the right to do that. But if that is something that, when you are buying a leasehold property and you think you're considering it, do speak to the solicitor so that if it's not applicable under your lease, just don't bother buying it and look for a property that is suitable. If it is, then great, they can help you, and then you can get a license to assign, sell it, or see what their procedure is if they allow you to buy, because not many freeholders will give you that right.
Yeah.
The other thing you were asking about is with lease extensions. So when it comes down, so generally with a lot of lenders, they don't like leases that are less than 70 years.
Yeah.
So once it starts to creep up, let's say you have a 90-year lease, once you're hitting the 80, 85 year, consider if you do want to stay or if you're going to sell. And if you are going to sell, chances are the value might go down if there's not that many years remaining. If it is, then great. If you want to stay in the property, then ask your freeholder if they consider a lease extension. Lease extensions, there's two different ways.
Yeah.
So again, review your lease, and you can speak with the freeholder and see if they are open to it. So there's two different ways, and for those who are interested, we can guide them through it. But they are very pricey, and they do take time. But it is an option, obviously, that's available. Anything else?
Yeah, that's it.
That's great. Another question, again related to immigration, that 7-year policy, the child policy, whether the parents' history, the immigration history matters or not. Well, if you're just talking about immigration history, they were legal, they were overstayed, it doesn't matter. However, if there is a serious nature of criminal background, then it may affect that particular parent's eligibility to have the status. Otherwise, it shouldn't matter. I would also stress on this that normally it says the paragraph which applies to it, it says that 7 years continuous residency of the child in UK. And people who, for example, were here on student visa, and during their student visa leave, they went to their country of origin, and within period of that visa, they came back, like for a few weeks, they went for holidays, and they came back and they continued staying here, and afterwards they became overstayed for another 2-3 years, and after 7 years they made this application. So there are 1 or 2 cases where Home Office has refused the application, stating that because you did leave the country, so your residency is not continuous. That is wrong. We have successfully challenged in the past. So hopefully Home Office will not refuse, but if this is the case, you need to challenge that, because that is not going to break your continuous residency if you left the country and came back within the same visa. And after that you became an overstay and you did not leave the country, so your residency is continuous. So again, parents' immigration history does not make any difference. Another question is that 10-year route. You have been granted leave under 10-year route, and you are saying that if you are working full-time, paying towards UK economy, being a good man in the country, can you get indefinite leave to remain after 5 years? Naisa, you think Home Office is going to grant this person indefinite leave to remain after 5 years if he was initially granted visa under 10-year category just because he's working full-time now?
It's a difficult question, especially, but as a lawyer I would say that Home Office has a discretion. You can always apply, and they can grant it, but I think it's quite an exceptional case. But discretion of the Secretary of State, they can do anything they want.
Yeah. Yeah, personally, I think no, this is not a good reason to do that by working full time, because they have given you right to work anyway. So they are expecting you to work and pay tax. So this will not change the Home Office heart that because you were initially granted 10-year route category and now we change it to 5. The only exception are those cases where normally people have obtained this visa under partner category, under human rights categories, that they were not legal but they somehow on family life basis did manage to get this visa for 30 months under 10-year category, but now because they were married, they have British spouse or a spouse with the present and settled status in the country, and they now go back to Home Office and make FLRM application, and then they will be transferring their category from 10 years to 5 years. So those 5 years will start from that date, not the time they have spent will not be counted there. So sorry, the answer is no. Under the rules it's not going to happen, but as Naji said, that discretion is always there. So if there's extraordinary case, you are doing 5 million turnover, you are making 2 million pounds profit, and you say, look, if you allow me and you grant me indefinite earlier because of my traveling, because of my business history, so those cases are exceptional cases. But what we are doing here is a general advice. So as a general advice, the answer is no. But again, every case depends on their own particular facts. A very common question, and we try to answer this in every session, and always so far the answer have been no. And again, the answer is no to that question, that if is Home Office considering any amnesty at the moment? We don't know. At the moment the answer is no. I wish they are. There are so many organizations, NGOs who are trying to convince Home Office that you need to consider those 1 million people, around 1 million people who do not have to live in this country and they're staying here, to grant them visa. There's another rumor or suggestion by other people that yes, Home Office is not going to make any such announcement, but however they are giving status to people, so come and make an application. So to some extent I only buy this. The reason being is that yes, because we have made so many applications where a particular client has not been staying in the UK for 20 years, but less than 20 years, but over 15 years. And they have very good business plan, as we were discussing earlier on, that he can show that he can contribute towards UK economy rather than getting status and looking for job. He will be able to provide job opportunities. So as I said, if you can create a case like that, you have got a skill, particular skill which is needed in the UK, you have particular qualification which can benefit UK economy. So yes, do come forward, consult your solicitors, legal advisor, consult us, info@m-rsolicitors.co.uk, and our telephone number is 0208 518 1956. So we will be able to guide you on that. But as a general answer, the answer unfortunately is no. We move on to our guest, Qazi Mian Sahib. He always tries to give us information on asylum categories. So let's see which category he has chosen today and what information he has for us. So if you have any questions, please do send us. Continue. We are still here for another few minutes. And if we cannot answer your question in today's session, we will respond your message, or you can send us email and we will respond accordingly. Guys, over to you.
So thank you. Actually, I always like to discuss about the delicate and sensitive issues of our society. And today I have a topic of the religious convergence. Basically, general conception is that religious conversion is conversion from major religion Islam to Christianity, or Christianity to Hinduism, or Hinduism to any of the religion. But that's true. It's a major category, but unfortunately there are subcategories from sect to sect, especially in our Muslim beliefs. So many people are subject to this conversion. So many girls, they are married into the different school of thought people, and it's recently so many cases reported that they force that lady to practice their way of, or to adopt their school of thought. So that is very concerning, and if someone has problem related to these issues, he or she should come forward and discuss with lawyers or discuss with the Home Office helpline. The second thing is, if I go back to the major religious conversion, currently it's a burning issue in subcontinent. Recently it's reported by Amnesty International and a few other organizations who do research on the human rights, and they do a very intense work in the field. It's in the Indian state of Haryana. So many Christians were forced to convert to Hinduism. So many Muslims forced to convert to Hinduism or any specific, obviously by a specific extremist groups. So if people have these sort of issues, they should come forward and they should raise their voice, and they should not adopt by force, and they should have right to practice their religious independently. Similarly, everyone aware of the Rohingya issues. That's the same issues is the biggest religious conversions in the world on the basis of their birthright. So these are the major and the minor categories of religious conversion and the sects conversions. So today we have less time remaining. So in next program I'll try to elaborate little bit further about the sects conversion, which are very, very intense and very, very sensitive between the Asian communities. And apart from this, I have another topic to discuss about, which we will discuss inshallah in our next program, that is related to forced marriages. So
That's quite a burning issue.
yeah, it is, yes indeed, yes. So these are
That's very quick, thank you. Brief but very concise information. So if you have any question in relation to these particular categories Qazi Imran Sahib has mentioned here, so please let us know and we will be able to guide you on that. And any general other questions you have, we can answer. There is a general question which is to do with mortgage, that you were earning money and now you want to apply for mortgage and there's a gap in your income. Will that affect? I think it is a question for a mortgage broker, but knowing limited information about it, if you need to have 6 months income, then you need to have 6 months income, and different lenders apply different criteria on that. So you need to consult a professional mortgage broker. He or she will be able to respond better. Thank you, Kabir Hanifa, for your appreciation, and all those who are appreciating this effort. Someone has commented about Qazi Imran Sahib, very handsome and professional.
Thank you.
So we appreciate your comments as well on that. There is a question that you got asylum here in USA. Okay, we are actually in UK, but the question is relevant in a sense that you are asking, after getting status like refugee status in USA and getting nationality like United States nationality, American nationality, can you go back to your country of origin? Yes, you can, because now you are not national of that country. Actually, you are national of a different country. So if you are going back to your country as an American national, not as a national of your initial country of origin, then you can. But if you're just taking the same passport again and going back to your country of origin, so when you come back, there may be problem for you. This is the standard criteria for UK and as well as America, Canada, any other country who grant you asylum, because the asylum was against that particular country. So if you have become a national of different country, then of course you can go. There shouldn't be any problem.
In addition, circumstances back home might have changed.
Definitely.
Yeah, that gives you another option.
Yeah, Sand was sorry if I missed your second part of questions. I tried to go through again, but I couldn't. But thank you for your appreciation for your answer for the first part. But if you have still in your mind, you can send us email, and we will try to respond to that. There's another question, and that is, me and my family became British citizen through naturalizations, holding British passport, and left UK around 4 years ago. Can we come back to UK now? If you're British national, you can come back to UK, to your country, anytime you want, even after staying 10, 20, 30, 50 years out of UK. You can always come back. The only difficulty may be when you come back and you try to rely on public funds here, you may not get so, depending on your national insurance contribution. So yes, as a general question, immigration, you are British national, you can come back, and even if you're staying overseas and you have further kids, by birth they are British nationals. So I hope that will be useful for you. There's another question. I have Irish residence card, and my wife is British. If we want to come back to UK and live there, means UK. Welcome. we are welcoming all those people who want to come back to UK. If your wife is British national, you have Irish residence card, you can come back here. Since if you have Irish residence card or EEA residence card of any EEA state, you can travel with your sponsor to any country of Europe without visa until this 31st of December 2020 at least. So if you can come back before that date, you can make an application for resident permit in the UK under regulation 9 of EEA regulations. So perfectly right, you can come back and get status in this country, which will be initially for 5 years and then indefinitely to remain, provided that your relationship is continuing. Thank you, Qazi Jawad Sahab, for again your appreciation. And okay, so second part of your question, Sahar Nawaz, was my father is in UK on visit visa, couldn't go back till now, probably you want to say. Can he switch to any other visa category within UK? Yes, whilst your father is here as a visitor, he can switch to any other category where he thinks he can. For an example, if he wants to make an application, he has business in his country of origin where he was working, and he is not the majority shareholder, he was minority shareholder, or he was an employee at management level, administration level, and his company says that we want to open a second branch in this country, and this is the person we want to appoint to run the show from this country. It is called sole representative of an overseas business. He can switch into that. He can switch into entrepreneur visa if he qualifies there. He can switch into work permit if he gets sponsorship license, work permit from a UK sponsor. And if he is old, like 65 or over, and there's no other parent, like your mother is not there anymore, and he is financially, physically, emotionally dependent upon you, then he can go to that parent route. It is a very high threshold, but you can consider that if he has any medical issues as well. So that is another category for parents. So I hope this time I have answered your question. Thank you, Akil, for the appreciation, and everybody else, Vikas Chaudhary, and all my professional friends who were watching, and then they give me feedback. And as I said to all my professional friends, please do join us, and the trail of information you have, please come and share with us. It will only grow.
Yeah.
So again, Naisab, it was very useful information for these sponsors here if they want to become sponsored as an employer.
Yes.
I think this is the right time, because after Brexit, UK is going to need more workforce. So if there are more sponsors, they can get. So you do look into the categories, the occupation shortage of occupation list, which the government changes time to time. So if people are falling under that categories, it will be very, very easier for you to sponsor them. Again, we also discussed on wills and probate issues. It's a very important category. You need to consider making wills. So if the time comes, there wouldn't be any problem after you, and things can be sorted very smoothly. You also shed some light on property matters, leasehold, freehold, and if you have further questions, you can always contact us. We have also briefly discussed some categories in asylum. We cannot give further details on that because it's a general information and it can vary case to case to a very, very great extent. So we refrain to give any specific advice to any particular religion or any particular sect or things like that, because it may work for you, but it may not work for the other one. So we do not want to make you more confused. So please do contact us. Our email is info@m-rsolicitors.co.uk if you want to make an appointment and come and see us. We have started seeing clients with social distancing in place for clients. The number is 0208-518-1956. Until our next session, next Wednesday, hopefully with the same panel. Whatever questions you have, please let us have them in advance, so when we come, we are well prepared to answer your questions there and then. So until then,